I was at a Labour court hearing there recently, and I'm representing a man who claims to have been unfairly dismissed. So the claim is essentially one of unfair dismissal, and the hearing has been adjourned for a different reason, and we're going back again obviously for another bite of the cherry the next occasion. But an important and interesting point made by the chairman of the division is that he was telling the other side, the employer, that what they needed to address the next day was two things. One, the fact that I had written to the employer claiming that my client had been unfairly dismissed and setting out the basis for that claim and so on, and the employer never replied. And secondly, the employee himself, before he came to me, had written to the employer saying that I understand that I'm going to be fired, and one of the supervisors told me, or one of the other colleagues told me, I'm going to be fired, can you please send on my P45 and I'll try and get alternative employment. The employer didn't reply to this either. So the employer then is claiming in the Labour court that the employee left the job and wasn't dismissed. But the employer has a problem, because as the chairman of the Labour court has told him, you need to prove or explain why on the next occasion you didn't reply to Mr. Gorry's letter and you didn't reply to the employee when both of them put it to you plainly that you had dismissed this man who has brought the claim. And that's an interesting point that has value and has a learning, as it were, for you. If, for example, you're claiming something about your employer, for example, not having paid you wages, or not having paid you a bonus, or not having paid you a commission, if you're ever wondering whether you should put your claim in an email or in a letter or in writing to the employer, for the reason I've just outlined, I think it is a good idea to actually state plainly in writing what your claim is, because later on you may well be glad that you made that plain or that claim in plain English to the other side, whoever it is, maybe your employer. And if the employer then simply ignores you and later on then comes along and says, well, we didn't know the money because of X, Y and Z, it may well be the case that the employer will be asked to explain, well, if that's the case and if that's what you're saying today, why didn't you reply at the time when it was put to you? I think that's a useful learning, and generally, you know, in making a claim, whether it's for a debt collection matter or for any other matter, I think it's always a good idea to write to the other side, either by letter or email, and set out plainly what exactly your claim is, and at least you have a documentary record of having made or stated your case. Hope you find this useful. If you do, you might give it a thumbs up down below, and you might be interested in subscribing to my YouTube channel. I have a lot of videos on the YouTube channel there dealing with all aspects of Irish law, and I try to explain Irish law and Irish business in plain English.